Hi, everyone, and welcome back to the channel. Tony here with Italian Dual Citizenship Assistance. And today's video is the third and final part of my exclusive interview with top Italian attorney Arturo Grasso. Now, if you haven't watched parts 1 and 2 yet, I would suggest that you follow the links in the description and go back and check out those videos first, and then come back to this one. Now, in the first two parts, we covered the July 31st decision from the Constitutional Court, as well as the June 25th Constitutional Court case and the significant impact that that case could have on everyone blocked by the new law. And we looked at the upcoming Supreme Court examination of the minor issue, as well as 1948 cases. Now, in part 3, we're going to discuss the future of Italian citizenship by descent and look closely at the options that exist for those who are currently blocked from eligibility. In other words, those who have been retroactively stripped of their right to Italian citizenship by the new law. Now, a quick reminder that I do offer affordable 20, 30, and 60-minute consultations for anyone who would like help understanding their eligibility options or best path forward toward becoming an Italian citizen by descent. Now, you can book your one-on-one consultation with me at italiandual.com, and the link is in the description. I hope you enjoy part 3 of my interview with Arturo Grasso.
The last thing I wanted to talk about, the last major point, is the future of recognition of Italian citizenship. Let's take a look at the evolution over the last 12 months and this move from a civil right to a legitimate interest, interest to naturalization.
Yeah, this is something I can see happening over the years, last year actually. There's more and more conditions or changes that are made by the government, by the consular approach. The consular approach, they took the minor case, but they left the 1948 case. So they didn't take the 1948 case, the consulate. They didn't bring in all the 1948 case, but they dismissed the minor case because they liked the ruling from 2023 and 2024, but they didn't like the rulings from this United Sections. But, so there are more and more conditions. And if you see, we couldn't believe that they could make worse than the initial decree 36, but they did with the law 74. What I can say is there's a change in the approach by the government, and also putting this in the law to make citizenship to become more like naturalization. We spoke about that earlier by saying the consulate has no commitment, really. They just look at the paper and say, yes, no, you have a change, misspelling here and there, you have to fix this and that.
Right.
But at the end of the process, they file everything in and send it to the Comune for registration. It's the Comune that does the hard job by transcribing everything and put that in the system.
Right.
And it's by the registrar of the Comune making the decision, the real difference, because by putting that into effect, the person becomes a citizen. But now the concept was to get more power by taking a decision, or the Ministry of Foreign Affairs, by making the central unit where they need to look at the documentation. And it looks like they coming up with a decision to say, yes, you have, yes, you don't, which is in a formal document or a formal decision on that. And that makes the process become more about an interest by an applicant to become an Italian citizen, and not a fundamental right as it has been so far. As you can see, they already created this category of citizenship by virtue of law, like for children. So whoever has been recognized a citizen of Italy by the consulate but lives abroad, their children who have not been registered yet, they need to make a declaration, the two parents together pay the money, and the child would have the citizenship only by virtue of law, but is not able to transmit citizenship. So this happens, more and more in the law. And that makes me believe that they would like to make this change by having a say on citizenship, or who is getting it, what kind of a condition. If you look at the condition required today, are no longer just provide the birth records. You need to provide all these conditions, was your parent exclusively Italian? It's on you, the burden of proof, to get to the comune and say to the municipality and ask, oh, give me a statement about that. But the commune is saying, the registrar is saying, I can make such a statement because I don't know, after 1992, everyone was free to get another citizenship. How do I know they got another multiple citizenship, maybe 10 citizenship around the world? I have no idea. I cannot make such a statement. But the consulate doesn't want to give you the citizenship without that document. The parents live 2 years in Italy. I cannot prove that myself. You have to get all these conditions together for the consulate or the registrar, the comune, if you apply in a municipality, to make a decision. And that makes the process become not straightforward, but based on a decision from a clerk to say yes or no, which resembles a decision from a legitimate interest, which we have in the public administration, where they come up with a decision. And the last consequence is that such a decision is no longer challenged before the civil court, but before administrative court. We have an independent court in Italy, which is the administrative regional courts, where we used 15 years ago, 20 years ago to challenge civil rights. And now it looks like we're going back to that court to provide that condition. And that doesn't look really good to me. And that's why I hope that the decision, the court will be vested, the constitutional court will be vested by multiple questions, which will address also this specific question, this fear that I'm having. And if not in the same Turin case, maybe later on, because I'm sure already have clients that do not like that their children get a sort of citizenship which cannot be passed to their grandchildren. They said, oh, we're going to challenge this because it looks like, you know, a sterilized citizenship. What kind of citizenship is that you got a passport, I'm a citizen of Italy, but I'm not able to pass on my children, which is, you know, that doesn't really sound good. So those are future questions which are going to reach the Constitutional Court, most probably, in the near future. And I can see there's a lot of challenge, and we need lots of clarification also from the how do we apply for children's citizenship, because we have so many questions by clients saying, what should we do? Should we wait? Should we make the declaration? And right now, there are already too long explanation about the interpretation, how to interpret the law by the Ministry of the Interiors, which already contradicts what's written in the law, but they take an approach. And in order to clarify if they're right, is that the way they say it, the Ministry of the Interiors, or they say the attorney sees that, we need to be in court, challenge the case, and see what the judge thinks about that, and set new precedents. So I see the future. I already said at the very beginning that cases today are very complex, are no longer the simple case where you add all documentation together and there's little or nothing legal arguments. Yeah, mention of the Constitutional Court of 75, of 83, which judges already know. The 1948 case, judges are already aware of that. We could totally skip that and just put documents together once. Today, there are so many complex aspects which we need to address in every single case that makes it very different and long.
Yeah, it seems like it has gotten so challenging. There was a time where people could just call the consulate and get answers to questions. That day is long since passed. It's really hard to get any answers of communication. So you're trying to put all this together in the dark for many people, just trying to do their best to interpret the law and figure out how to gather all these documents. Now we're seeing the request for this historical certificate of citizenship. We mentioned this in our last interview. You mentioned speaking with some of the clerks at the comune, like how there was no requirement to report a naturalization outside of Italy prior to 1992. So how does this certificate of historical certificate of
Facility.
citizenship how is it possible for the community to produce this? How does it do anything different than simply, showing that the person was born based on their birth certificate that was registered at the comune? Certainly they could say, as far as we know, this person maintained their Italian citizenship, but they have no way of knowing. And the comune it turns out, in practicality, we're having a very hard time. Many clients are having a very hard time actually getting the comune to produce this required document. So a lot of people are going to be blocked by simply not being able to provide the documentation required through the consulates. So I'd love to get your thoughts on all of that mess.
Well, about the children, we're saying about the minor children, people that they did not file with the minor children, or they have still minor children out, born before March 28. We suggest to wait for the decision from the Constitutional Court before, because if the decision says that whoever was born is already a citizen, the minor children, they ought to be registered right away by the comune, and they become dual citizen with full right of citizenship, just like their parents, though being born abroad. But if that's not the case, or the Constitutional Court would delay, they should register the way the new law says, but that child will have no right to pass the citizenship of their children. So it's a gamble. But I would suggest to wait until up to March, April, before they take a step and register the child with the consulate, not with the commune anymore. It looks like just with the consulate. They have to reach the consulate to register. There will be a long queue, but that's what's going to happen. And again, one of my clients already said, I'm not buying this. My child has to get full citizenship, not just this sterilized citizenship, which is not able to pass on their children, and is ready to challenge that. So we'll wait the last minute. If it goes with the Constitutional Court, fine. If it doesn't, it will file a claim against this provision. And by filing claim for this provision, this other provision, this other thing, we're creating precedents. It will take a long time to get this precedent set, from different courts.
So the number of people who are going to even qualify at all through the consulates or the comune has gone down precipitously. There's a very small percentage of people who are even going to qualify to attempt going through that process, and fewer still who are probably going to be able to produce all of the documents required, like this historical certificate of citizenship that's being required for certain things, such as the reacquisition process is one where that document has been requested from most of the consulates that have finally started putting information up on their websites. They're asking people to obtain this historical certificate of citizenship, or sometimes a historical certificate of residency in Italy also, which are proving sometimes hard to get. Some comuni are saying they can only provide a birth certificate and a marriage record, but not these historical certificates of citizenship or residency. So people who are already blocked by the parameters of the law, by the minor issue, by the 2-generational limit, by the exclusivity of citizenship of a parent or grandparent, all of these things, plus those who are blocked by not being able to obtain the required documents, not being able to pass this rigorous test that they're going to have to go through to apply at the consulate. What advice do you have for those people right now? How should they consider moving forward and be able to stand a chance of still claiming their recognition of their Italian citizenship by descent?
Well, where they're blocked, the only way will be challenge this provision. Waiting again, it will take time to have all this different situation clear, because as you can see with the new provision with the Constitutional Court, it takes time to set a new precedent. Look at the minor case. It started in 2019 by the Court of Rome to have opposite decision and applying Article 12. We are in 2025 to get before the Court of Cassatione, the Supreme Court, and we might get a decision by the end of the year. So 4 5.5 years. So the only way would be challenging or wait for all these years. There's no other way to do this. If the clerk of the comune doesn't want to provide the document, which some smart one, they understand, as they say, how can I assess such, that he was exclusively Italian, he could have lived anywhere in the world and get citizenship from anywhere. And so I'm not able to. And if that blocks your application, the only chance will go move to court and apply for a decision by the court that will clear such a situation. And you need multiple decisions to have a strong precedent, which is going to be maybe even decided by a court of appeals, to have a consolidated precedent and say this is the new approach. Again, for some people today also decide to move forward with a court case because the council doesn't have an appointment. So the no appointment case, which was one of the past precedents of a past legal framework, still applies today because they try to apply but they have no chance to apply. And sometimes they wonder if they need to apply with second or third generation, together with the third and fourth generations, because there may be parents are eligible and further generation are not. And we always, talk to them and suggest that each case is very different from each other. And we believe, we strongly believe, whoever was already born by March before the decree law should really apply within the same case and get a chance to be approved altogether with a family. Because if you apply today, a client that reaches you today, it will not file before a year. By then, the decision, first of all, they can make a decision just before, when they're ready with the documentation, because they collect everything together. It would be for speedy filing, you need to have documents at hand. You can't believe that if there's any opening by the Constitutional Court, you will file right away in a month. You need time to do that. So collect the document and be ready by the time you're ready to file. And take a decision when you're ready to file. But most importantly, by the time you get a hearing, a decision, the Constitutional Court will already be assessed your case. But again, to those who struggle with a consulate, there's nothing really that an attorney can do to convince the consulate. They depend by the Ministry of the Exterior Affairs, and they connected to the Ministry of the Interior instructions. So really, there's nothing we can do as attorney to convince the consulate, rather than challenging obstacles that they put, or impediments to have your case recognized.
So the route for somebody blocked from applying at the consulates would be to file it as a court case instead of a consular case. Now, based on that, there are several potential avenues. You mentioned that they have the option of a no appointments case.
Yes.
If someone hasn't been obtaining,
if they're blocked, is like equal to be rejected. Because if they're blocked and the council doesn't give an answer, and that council doesn't come in within a reasonable time, and you do not need to wait 2 years or 3 years or 5 years to go move to court, because that's a denial of citizenship. They're not going to change that.
So if someone doesn't have a 1948 case, which is a common reason to be in court, and their only option is to go through the consulates, but they're blocked, should they apply at the consulates and get rejected? Or can people take cases to court that are simply challenging the new law or challenging the fact that they couldn't get an appointment? What's the best way to get someone into court?
The best way would be apply and wait to be rejected. It has not become yet, for any of this situation, a principle or a precedent like the no appointment case, because the no appointment case has become a principle and a precedent that if you wait for so long and you know that the consulate has no opening with no appointments, waiting even a month or two with the evidence of a month or two is a precedent. Now we need to create a new precedent for these other cases and say, where the consulate is not allowing you to file a case for because you cannot get this exclusivity documentation, is like a rejection. Why shall I wait 2 years like for an administrative president? Because that's administrative presidents wait 2 years. This is a fundamental right. I do not need to wait such a long time. So I would suggest to collect evidence that this is the approach towards their cases and file to court in order to set a precedent, a new precedent, or have the judge to decide on the matter.
So it would still be advisable for those trying to obtain consular appointments and having challenges getting them to document their attempts, to perhaps screenshot, show the attempts, show the inability to get an appointment.
For the no appointment, yes.
For no
if they have the case that they believe they're going to be rejected by the consul because of something, it still needs a no appointment if he wants to file right away. No appointment is one issue. So because of the no appointment, he can move to court like it was in the past. If he can get appointment and feels that he's going to be rejected, he needs to take the appointment and be at the appointment first. Because otherwise the judge would say, why are you coming to the court? You had an appointment. I mean, you could go to the consulate. And that's not, some judges they say, well, you not really need to get an appointment, very few. But some others, they say, why are you coming before a judge if you get a chance to get an appointment? And they dismiss the case. So you waste the time even and the money to get to court. So it's advisable for me, from my end, I say, if you get an opening and you got an appointment within a reasonable time, get the appointment, show up at the consulate, and come back with a letter where they say they reject your case because you don't have this document. I need an evidence about that. I can't just tell the judge. If my client tells me.
So what about those people then who know that they won't qualify based on the current parameters of the law? Like they don't have the exclusive Italian citizenship from a parent or grandparent, or their last Italian-born ancestor is a great-grandparent. Should they consider trying to get an appointment and get rejected still, or should they find some way to move to court?
If the rejection is obvious because against the law, the new law, they can go to court. But the same moment I bring them to court, I would say as a first reason for the judge to award citizenship is that they were born already before March 28. So in that, when I go to court, I change the perspective. I no longer use the decree law arguments, because I would say, those people, I mean, to say why we are in court, to say because the consul will not take them, because it's the law says this way. However, you must grant them citizenship because they're already born. Only as a second shot, I would say, if you would not apply the past legal framework or wait for the constitutional court decision, then yes, okay, consider the decree law. And this is what happens with people that may qualify. For instance, I already have I had a 1948 case brought before the Court of Palermo, filed after, in reality it was filed on March 28th, so the same day. And what the judge, it was, according to the new decree law, the case would have passed. And the judge, I mean, I said, first of all, she was already born, so I would apply the past legal framework. And the judge said, yeah, but she would also qualify according to the new legal framework. I said, okay, then qualify with the new one. But I didn't like that, but because the new legal framework, I would accept the new decree law. But it was okay. So with cases where they qualify, if the judge wants to take a decision and say you have a 2 generation, then a 3 generation. If the judge wants to go with the 2 generations, say, well, they qualify, let me make a partial decision, that's possible. The judge can make a right away decision and say, okay, I make a decision, they qualify and they're citizen. For the other one, let's wait for the Constitutional Court. It can do that and just split the cases in 2. Qualify one, make a decision, and the other 2.
Yeah.
So the first one will qualify with a new legal framework. The 3rd and 4th generation one will qualify according to the Constitutional Court precedent and the past legal framework. It's a complex, cases are complex today. Again, we review each case in detail, and plan for a strategy, because you can go multiple ways, and there's a matter of decision with the client which way they like to go. And what we suggest, of course, according to our experience and legal prediction.
Got it. So for people who are just starting out in this process, and as you've mentioned, it's so complex, would you prefer to see people come directly to you who are just starting out, who don't understand how it all works, who don't have documents and don't understand where their case begins or where it ends? Or would you prefer that they get some assistance from somebody who can help them get clear on what their options are and what documents they need, and start gathering the key documents that might show their eligibility and get them closer to being to that point where they can actually file their case in court? What would your advice be for somebody just starting out?
I believe that reaching out to someone who already works in this field is a good approach, because they know complication, which way to go, and we discuss when we work together. We have a new case. When they reach out to us, we examine the case, and we have our case assessment team that analyze the matter and the case. But we do the very same with whoever collects the documentation and does the job. So if people reach out to you and you tell them what's the case, you already have an experience on the general standard of this case. And wherever you don't, something is tricky and you believe that there's some complication, you're always welcome to reach out to us and explore together what might be the best option and continue the work. Because if someone needs the assistance to procure the documentation, there's no way they can work with an attorney who does not, and we do not. We suggest what to do. We suggest what we need, but it's on the client to procure to bring the documentation to us. So we work together for a long time. But if they can procure the document themselves and they need help for that, that's even better. Just so they can talk to you, bring, get the standard documentation, and then if there are complications, let us know.
And I know that you and I have been working together with a number of clients for over the past months now, and I've been really enjoying the collaboration where we can help clients get their documents prepared, get them ready so that your team doesn't have to deal with that element of it, and we can just get those cases filed in court. And when I refer them on to you that they're pretty much ready to go at that point, and you can get their cases filed. So I really appreciate your collaboration. I look forward to working with you more.
Especially now that we need a lot of effort now this time to work on each cases. For I say, if drafting a petition would require normally half a day, 1 day, today requires a couple of days, and requires to go back and rethinking. Perhaps I forgot about, sometimes I go back and forth sometimes in new cases. And just maybe I need to add also this detail or this new present or this new opening with minor cases. You have to go back and it takes a long time. So we need to concentrate on the legal side, legal aspect with the legal team. If we have the documentation ready, that will take off some of our problems in the initial steps of the process to help people to procure documentation in the proper way. And so we can concentrate more on the legal side. That's what we need right now this time. If we got the documentation set ready, almost ready, that would, it's good for us.
Arturo, thank you very much for your time again. It's been a wonderful conversation. You've
been my pleasure, Tony.
So much on everything that's going on. I appreciate your collaboration. We've been collaborating on a number of clients, and I love that the work that you're doing and the help that you're giving people and the spirit that you're bringing to all of this. So thank you. I think I can speak for the entire Italian dual citizenship and citizenship by descent community and thanking you for your work on this subject.
Really, it's my pleasure, but I must also add, it's just not myself only. I got a very supportive team. Everyone is really behind me, is behind the scenes, are working diligently with me to make this happen. So I must thank you everyone for this behind me.
Well, thank you very much, Arturo. I know that people are really going to get a lot out of this conversation. Thank you for your time. I can't wait to come meet you in Orvieto someday soon and see you in person
Rome
and
or
meet
Vieto,
everyone on the
wherever
team.
you come, I will be there.
All right, Arturo, thank you so much for your time. I appreciate you very much. I'm grateful for your time
My
and
pleasure.
consideration on this.
Grazie mille.
I hope you enjoyed this three-part series with top Italian attorney Arturo Grasso. Mr. Grasso gives us lots to be hopeful for between the Italian Constitutional Court's examination of the constitutionality of the new law, the Supreme Court's examination of the minor issue that has blocked so many people, and the possibility of filing individual court cases to challenge the new law's retroactive application. Like most top Italian attorneys, he suggests that you gather the required documents and records and be ready to take advantage of a window of opportunity that may open through all of the current legal and constitutional challenges to the new law. And as you heard him say toward the end of today's video, his firm does not get involved with the gathering of the required documents needed to file your case. This is something that I do assist people with and help people to prepare a successful case and then hand them off to a great attorney like Mr. Grasso when the time is right. Now, if you'd like some help understanding your eligibility and options, or would like to get started collecting the required records and documents to apply for your recognition of Italian citizenship, I do offer affordable 20, 30, and 60-minute consultations where I can help you get clear on how to move quickly and efficiently toward having your case ready to go when the time is right. Now, you can book your one-on-one consultation with me on my website at italiandual.com. I look forward to speaking with you, and I'll see you in the next video.